The plaintiff attorney has indicated that he has sent a dismissal, and I just want to confirm.
It's in the file. It's in the file.
The dismissal is in the file. I will sign off on that dismissal. We do have that on the docket.
Okay. Okay, so no need to continue, or you want me to hang around till we get it on the record?
I don't think that you have to hang around on that one. If there's a
Okay.
dismissal, I will sign off on that.
Thank you so much, Judge.
Thank you. The court calls case number 20-348516. This is River Towers
Thank you.
versus Helena Williams and other occupants of property located at 7800 East Jefferson, apartment 1128. The court also calls the suffix 8520. That's River Towers versus Bernard Jackson and other occupants of property at 7800 East Jefferson, apartment 410. The court is calling the suffix 8544. That's River Towers versus Manuel Williams and other occupants of property located at 7800 East Jefferson, apartment 503. The court is calling suffix 8548. That is River Towers versus Leroy Daniels and other occupants of property at 7800 East Jefferson, apartment 426. The court is calling 78548. That is Motown Rentals LLC versus Anthony Garrett. All right. Your appearance at this time, counsel. Mr. Ravitz, I believe that you're still muted, sir. I've asked other persons on the Zoom, please mute yourself so that I hear sound from your device. Mr. Ravitz, you may at this time.
Sorry about that. Lee Ravitz appearing on behalf of the plaintiff in each of these matters.
All right, thank you, counsel. Is there opposing counsel on either of these matters that I've called at this time? If you're an attorney on either of these matters, please give me an indication right now your appearance at this time. All right. It looks like with regard to each of these, they may very well be up for the first time. Let me see if I have, do I have Helena Williams on the Zoom? If you're on the Zoom, please say something.
Yes, sir. Yes, Your Honor.
All right, I'm looking for you. Say something one more time, if you will. Say good morning.
Yes, Your Honor. This is Helena Williams. Good morning.
I got you, Miss Williams, and good morning to you. Put your name in there. All right, you live at the property on East Jefferson, 1128. Is that correct, ma'am?
Yes, Your Honor. I'm also in Judge Coleman's courtroom at the moment. But yes,
Right.
Please adjourn to March 12th.
All right, I got way too much going on here. Miss Williams, just hold tight for a second.
Well, his cases are second hearings, so mine were first.
All right, so Ms. Williams, have you had an opportunity to speak with a lawyer regarding the matter that you had before the court and regarding ways you might be able to resolve this matter, ma'am?
Not a lawyer, not an attorney, but
Thank you.
I was
I'll be back in just a few minutes, Judge.
Just one moment.
Judge Coleman.
I'm sorry, Judge. I was in front of Judge Millender for a moment.
All right.
Does
All
Ms.
right.
Williams want to speak to me?
Just one moment, sir. If you have to go to another spot, just mute yourself here. I'll wait till you come back if that happens so that we don't get the sound in the system, Mr. Rabbit. All right.
I apologize.
Not a problem, sir. So, Ms. Williams, you like to talk with someone that can give you some advice regarding the matter you had before the court. Is that correct, ma'am?
Well, you know what? The United Housing Coalition had been by here, and I was on their program. Actually, they were here about a month ago, and they informed me that the rent would be taken care of until March, actually.
All right. So, did you speak with a lawyer at that time, or just you spoke with some personnel at the office here? Is that correct? Which one?
No, not a lawyer, just people at
Let me see if
United Housing Coalition.
Let me see if I can get you someone that will talk to you today. This seems to be the first time that this case is up. And so I'm going to set the matter over for the next action date. And that date is going to be February the 8th.
February
Just one moment.
She gave you the eighth. What day did you have it?
Well, I
The eighth?
used that yesterday.
Oh, the eighth. Okay, so then today you're gonna use mine.
All right. February 9th, 2021 at 9 o'clock a.m. That'll be your next action date on this matter. Before you leave, I'm going to have you to speak with a lawyer that can give you some advice and direction regarding the matter that you have before the court. You understand, ma'am?
Yes, sir. I thank you.
And you got the new date. Is that true?
Yes, I do. February the 9th.
At 9 o'clock a.m. And Mr. Rabbit, you have that information as well. Is that correct?
Yes, I do.
All right. So who's able to speak with Miss Thomas?
I am, Your Honor.
Miss
Kelsey,
Williams at this time. I'm sorry.
I am, sorry, Kelsey Sill. And can you put me and Rima from Lakeshore in a breakout room with her?
All right, I will do that, and that's going to be breakout room number 1. So I'm going to send you there. Miss Attorney Seal is going to speak with you, ma'am, and so I'm going to send you to breakout room number 1.
Is this Miss Williams, Helena Williams, Judge Coleman?
I'm talking to Helena Williams right now. Ms. Williams, I'm
Okay.
sending you to breakout room number 1. There's your prompter. You should see it on your device.
Yes, I do. Okay, thank you.
Go ahead and click in, and Ms. Seal will be there momentarily. And who was the other person that I was sending to that breakout room? Say
Good morning,
something?
Your Honor. It's Rima Kakarli with Lakeshore.
Okay, got you, Ms. Kakari. All right, and there you are, ma'am. Good day to you.
Thank you so much.
All right, regarding the suffix 520, I'm looking for Bernard Jackson and any occupant of property at East Jefferson, apartment 410. If you're on the
That matter
Zoom,
should be dismissed.
and
That matter should be dismissed, Your Honor.
thank you, Mr. Rabbits. I received that. I will dismiss this matter. I don't have the order in the file, but I'll await the order for dismissal of this matter. Regarding the suffix 544, Manuel Williams regarding property on East Jefferson. Do I have Manuel Williams on this Zoom? All right. That matter will, given that it's the first hearing, that matter will in fact be set over for the 9th of February at 9 o'clock a.m. It's 2/9/21, 9 o'clock a.m. The next action date on that matter. I'm looking for Leroy Daniels regarding the suffix 548 on East Jefferson. Mr. Daniels, if you're on the Zoom or someone that lives at that location, please identify yourself at this time. All right, that matter will be set over for the 9th of February as well. This is the first hearing under the administrative order. The court would automatically set this on for the second hearing, and that would be the 9th. And that's going to be at 9 o'clock a.m. on each of these matters where defendants have not appeared. If they do not appear at the next hearing, the court will entertain a motion for entry of judgment by default. In regard to the suffix 548, that's Motown versus Anthony Garrett. Mr. Garrett, if you're on the Zoom, say something. If anybody at Whittingham, the lower unit. All right, hearing no response, it does appear that this is the first hearing regarding this matter. Therefore, the court will set the matter over for the next action date. That next action date would be the 9th of February, and that's going to be at 9 o'clock a.m. And Mr. Rabbits, of course, the intent here is to put everything over to the same time so that you won't have to switch around dates.
Thank you. Appreciate it.
All right, thank you, sir. All right, and let me deal with some
I
of
do
the
have a number of
matters.
other, they're later. Okay.
I'm sorry, Mr. Rabbits.
No, I do have a number of other ones, but they're a little later.
All right, I'll
I
get
do
to
have-
them. I'll get to them
I
in
do
due
have one
course.
for Fred Coleman at 9:30.
All right, that one was in the package that I just referenced. That last one, that was Fred Coleman's 9:30. sir.
Oh, okay, great. That's adjourned. Okay, Judge, thank you. Then I'll go back to Judge Millender's courtroom and I'll come back to you in just a little bit. Thank you.
Yes, sir. I'll see you in just a moment. All right, this is case number, Mr. Devlin, are you there, sir?
Judge, this is Lockhart. I happen to know Devlin's and Judge Millender right now.
All right, thank you. This is case, I'm going to call the matter. This is case number 23-4-8532. This is Irvine Apartments versus Asia Bellamy regarding the premises at 1021 Covington Drive. There is a proposed order of consent, a proposed consent order of conditional dismissal in the file in this matter. I know that Mr. Devlin is in another courtroom. Do I have counsel for defendant on the other side in this matter? Do I have Aisha Bellamy on this Zoom? All right, looks like the respective parties have signed off on this. I will go ahead and grant the relief requested. The matter be conditionally dismissed. That conditional dismissal is on the terms as set forth in the written document that has been submitted to the court. It is so ordered. Mr. Devlin also has the suffix 8536. In that matter, it is a complaint for non-payment of rent. That is Irvine versus Waller. Look like Deborah Waller. Laura, I'm sorry, that's Laura Waller. The court has received the proof of service offered in this matter by attachment. This appears to be the first date of hearing regarding this matter. Do I have on this Zoom Laura Waller? Laura Waller. Person living and occupying the property on Manderson Street. You're on the Zoom. Please say something at this time. It appears the defendant has not appeared regarding this matter. It is a first hearing. Well, I'm seeing somebody, Tequila Wall. What's your name, ma'am? Can you unmute yourself? Well, that's Wester. Okay, I got you. No problem. Not a problem. All right. So on this matter, I will set it for the 9th of February 2020, and that'll be set for 9 o'clock a.m. That will be the new date on this matter. Defendant does not appear at that time. The court would entertain a motion for entry of judgment by default. The court now calls the suffix, strike at case number 23-4805, strike that 75. That is 8075. Spot Realty Incorporated versus McGee, Carney McGee regarding property 12086 Lauder. Your appearance, counsel, do I have Mr. Wine? You're on the Zoom.
Good morning, Your Honor. Eric Wine for the plaintiff, P56893.
All right, thank you, counsel. Good morning to you. I do see that this matter is before the court on a complaint for non-payment of rent. It looks like the first hearing on this matter as well. Let me see if I have Ms. McGee.
It's actually this is the second hearing, Your Honor. We were before Your Honor on January 5th.
Oh, I am seeing that in the file. One moment, sir. McGee, Ms. McGee, do I have McGee on Lauder Street on this Zoom? If you're here, say something at this time. And thank you, Mr. Wine. I do see that notation now in the file regarding the 5th. I set it over for this date, giving the defendant another opportunity to appear in this matter. Counsel, your pleasure at this time, sir.
Your Honor, the defendant currently owes unpaid rent in the amount of $3,080.
Let me stop you for just a moment. You're moving for entry of default on the terms that you'll submit in a written document. Is that correct, sir?
That's correct, Your Honor. In fact, there's a proposed judgment form before Your Honor. It's only missing the amount of the rent and the total with the court costs.
All right, let's see what you have here. All right. So I do see the court costs of $160 contained in that document. All right, so you can go ahead now. The rent to retain possession, what is the amount that you have calculated now, sir?
It is $3,080, Your Honor.
All right, and so I have the $3,080 and the $160 in costs. Any other thing I should be putting here, sir?
No, Your Honor, just a total of $3,240.
You calculated $3,240?
Yes, I added $3,080 and $160.
I figured that's what you get. You saved me from having to calculate this work. All right, sir. I will grant the judgment by default at this time on the failure of defendant to appear in this matter, otherwise plead. And the judgment is being signed at this time, sir. So ordered.
Thank you, Your Honor.
Thank you. Good day, sir. That amount must be paid on before the 25th of January or after that date, a writ will issue allowing for eviction from the property. So,
Thank you. Have a nice day.
a nice day to you as well, sir. This is case number 23-47501. This is Fountain Court Cooperative versus Shamira Collins, and occupants of property located at 3404 Lawton Street, number 3B, Unit 233. Your appearance regarding this matter, sir.
Morning, Your Honor. Creighton Gallup, P63002 on behalf of plaintiff. Your Honor, this is the second hearing. We were here on, I believe it was December 3rd. The defendant was not there present that date. I don't believe she is present today. We believe she has vacated the premises, so we would ask for a judgment by default, Your Honor.
All right, you said you were here on the 3rd of December. We were closed then.
Well, it looks like it was adjourned originally. It was adjourned for November 6th, and it looked like it may have got pushed to the 3rd, and it may have been pushed another date after that, Your Honor. But I know we've been there within the last 30 days or so.
All right, so if this was during the shutdown, then that would not, we could not have functioned on any of those dates. And I don't have a notation about what I'm going to do, counsel, is I'm going to get something printed out on this to see just what happened, because the only thing I have is the 6th of November at 8:50, and I believe we were closed by that time. The case number is 23-47501. And for some reason, the name in this file and the address does stick out to me. So let me look at the register of action to see what happened. All right, looking at the register of action, it indicates that the hearing of the 6th of November was adjourned. And then it indicates that there was some action on the 3rd of December. So there's been at least one hearing, as you've indicated, counsel. I'm satisfied at this time. The court will enter judgment by default upon presentment to the court finding that the defendant has failed to appear or otherwise defend in this matter.
Appreciate it, Judge. We'll submit it. Thank you, Your Honor.
All right, thank you, sir. Good day to you.
Thank you. Good weekend, sir.
All right, so on this one, you said you had someone on the phone on this case.
Yeah, she's on the phone. We can't see her, Mr. Morris. Both
All right,
of them
all right.
are here.
This is case number 23-48524. This is Jesse D. Morris versus Louise Morris and other occupants of property located in the city of Detroit at 3037 Elmhurst. The matter is before the court on the filing of a complaint for non-payment of rent. Do I have Jesse Morris on this Zoom?
Good morning, Your Honor. Yes, you do. It's a pleasure to be here looking at you. I am calling. I'm pleased, hoping that you help.
All right. Well, I'm here to help within the parameters that the law allows. And good morning to you, ma'am. It's good to see you as well. You own the property on Elmhurst. Is that correct, ma'am?
That's correct.
All right. And let me see if there is Lucille Morris on the Zoom. If you're somewhere on the Zoom, please say something at this time. Ms. Morris?
Your Honor.
Yes. Ms. Snow?
Your Honor. Thank you. Charlene Snow from United Community Housing Coalition, P26923. Your Honor, I'm here in place of Gerald Featherson from our office. And I believe this is the file where Lucille Morris, and she has a daughter, Gwendolyn Morris Crawford, who has been in contact with Mr. Featherson, who can't be here this morning. And I think this is the first hearing on this matter, and we would ask that it be adjourned so that Mr. Featherson can have some discussions with Lucille Morris and Gwendolyn, and also perhaps with Ms. Jessie Morris, so that we can find out if there's a possibility of getting this rent paid.
All right. It is the first hearing on this matter, and thank you, Ms. Snow. It is the first hearing, and by administrative rule and order, the court would have to set it over for a second hearing in any event, and there's a specific request in that regard. So that's what's going to happen today, Ms. Morris, is that I'm going to set it for the next action date. The date that I'm working with now is February the 9th, and I could set this over for 9:00 a.m.
Your Honor.
I understand that there's an attorney involved in this matter as well.
Your Honor, we would ask if we could that you set it for a date when UCHC is in the courtroom. That would be either a Monday, Wednesday, or Thursday.
10th is the 10th.
Because Friday is a Lakeshore Day and Tuesday
so-
is a Lakeshore Day.
So the 10th is what my clerk is indicating. February 10th, 2021 at 9:00 a.m. Ms. Morris, that'll be the next action date, the first time that I can do anything regarding.
Your Honor.
Yes, ma'am.
Your Honor, I have a critically ill sister and I am 90 years old. I've tolerated this for a year now. Can you help me?
Some of them up here.
I am 90 years old and this tenant, Morris, we're no kin, and they have been totally ridiculous to the precinct. And I've been with the precinct for many years. And my sister is critical and she needs me. And she's on the second floor and the driveway is ridiculous with them. Please help me evict them immediately.
I don't have any law that would allow me to do that, ma'am. So in these pandemic times, the Supreme Court for the state of Michigan has issued a new set of rules, and those rules govern what I can and cannot do during this time. And under the administrative rules of the state of Michigan during this pandemic, I have to adjourn that first hearing and give it my next action date. And so that's what's happening here. I will mark the file as one that the court should give some attention to as it relates to time. And so the next action date, we'll review all of those matters at that time. All right. I do wish you well. All the best to you. And 90 looks
Thank
great
you.
on you. I hope that some of that is rubbing off on me because I need to be around that long because I have
Amen.
I have a 7-year-old and a 9-year-old, so I got to stick around.
Oh, listen, I don't know if I'm going to stick around that long.
You
But
got it, man.
It's an honor again. I've been an excellent worker in the city of Detroit with the police department. And I am sick of this toleration that Mrs. Lucille Morris, no kin to me, no kin to my husband. My husband is a Morris and I'm not a Morris. I'm a Harris.
All right. All right, ma'am.
Thank you. Thank you for listening to me. And it's an honor.
I appreciate it, ma'am. And thank you for being here. And I love your energy, ma'am. All right.
Yes, thank you.
We'll see you at the next action. All right.
Sure.
Good day to you.
Good day.
Thank you, Your Honor.
Thank you. The court now addresses 234705 RTA Holdings LLC versus Shemaiah. I do have contained within that file an application for judgment. I also have a dismissal regarding this matter. Counsel, your appearance at this time, sir.
Good morning, Your Honor. Randy Lavasser, P41712, appearing on behalf of the plaintiff.
All right, and do I have someone on the other side on this, your appearance, if you will? All right, so counsel, what's going on here, sir?
I'm aware of a proposed consent judgment. I'm not familiar with the dismissal that you indicated you have. I'm wondering if it's in the wrong file, Your Honor. I'm kind of surprised by that.
Now,
Your Honor, it appears that,
please, Ms. Enright, you're saying something now?
I'm sorry, Your Honor, it appears that Indra is on this case. If you could hang on for a second, I can get her to come over here and address that a little bit more fully.
Very well. We'll come back to this. Mr. Lavasser, it does, there is that dismissal that's in this file does not belong here, so I pulled it out. I do see an application for entry of a consent judgment in this matter. That's what seems to be going on. And so it looks like Ms. Indra has signed off on this document. Mr. Lavasser, that's your understanding as well?
Yes, it is.
All right. So that judgment seems that it would allow for entry of a judgment by consent for $5,806.60. It would indicate that 50% or more of the land contract balance has been paid. That would give the defendant 6 months to resolve the difference. The defendant would have until the 15th of July, 2021. If it's not resolved or cured, then a judgment would, I should say that a writ would issue allowing for eviction from the property. Is that the agreement, Mr. Lavasser?
Yes, Your Honor.
All right. I think that's clear enough, and I appreciate Ms. Enright's input here. Do I have on this Zoom this Fruitwell or any occupant of the property there on West Chicago? All right. I do see you there, ma'am, and good morning to you.
Good morning.
All right. You've heard me go over the terms related to this agreement that your attorney is up on. This is your understanding and your expectation as to the outcome of this matter?
Yes.
All right. All right. So what I'm going to do is I will now go ahead and sign off on the document, and that will be the order in this case. You'll have until the 15th of July to satisfy that balance of $5,806.60. And if that's done, then that would be the end of this case. And I believe that would be the satisfaction of the land contract balance. Is that correct, Counsel?
Well, I know it would satisfy the arrearage. I don't know that would satisfy the contract in full. Gotcha.
All right, I do see. Well, all right, ma'am, is it your understanding that that's the balance on the land contract, or it is some other amount, you know?
Yes, that's my understanding.
That's the balance, correct?
Yes.
Yeah, I'm looking at the original filing, and that may very well be true, although I can't say it affirmatively. I will sign off on this, and as long as you take care of it by that date, then that would constitute the end of this matter. Understand?
Yes.
All right. I wish you well, ma'am. You'll
Thank
get a copy. All right. Thank you. Good day to you.
Good day.
Thank you, Your Honor.
Thank you, Your Honor.
Judge, I hate to interrupt you. This is Kelsey Sill, P83841, on behalf of Miss Helena Williams. Would you be able to put me in a breakout room with the opposing counsel on this matter?
That's Mr. Who was on that one? That maybe
It's
gone.
River Towers versus Helena Williams. I'm not sure who the.
It's Mr. Rabbits. Mr. Rabbits, Miss Sill would like to speak with you. It looks like Mr. Rabbits may be in another. Yeah.
Okay. That as soon as he comes back, then I guess if we could have a breakout room, that would be great, Judge.
And if you will, Miss Sill, if you could chat him.
Okay.
And then I'll set it up once you made some contact with him. Okay.
Okay, will do. Thank you.
All right. Appreciate it, ma'am. Ladies and gentlemen, you do have to keep your devices muted while waiting, because if it's not, then I end up having too much sound in the system, and that doesn't work so well. So please keep your device muted for me. Appreciate it. The court is now calling 23-48079. This is Harold Villa versus Charity Irvin and other occupants of property located in the city of Detroit at 19484 Concord. Your appearance at this time, counsel. Mr. Flesland? Mr. Flesland, are you
Yes,
able to?
yes, Your Honor.
Are your appearance regarding Vella versus Charity suffix 079?
Oh, yes, Your Honor. May it please the court, my name is Dennis Flesland, P30289, appearing on behalf of the plaintiff in this matter. I am standing in for Mr. Sagatti this morning, Your Honor.
All right, thank you, sir. Do I have Charity Urban on this Zoom? Say something if you're here. If you're on this Zoom, if you have to say something now. If you're muted, just unmute yourself so that I can hear you.
Yes, Your Honor, this is the second hearing on this matter. Our file does reflect that she was personally served on November 9th with this summons and complaint. So on that basis, I'd ask for a default judgment, Your Honor.
All right. And let me just check one more time.
Hello? Hello?
Yes. What's your name,
Yes,
ma'am?
this is Charity Irvin. I'm here.
All right. Thank you, Ms. Irvin. Let me put your name in there, ma'am. Just one moment. All right. This is the second hearing with respect to this matter. Ms. Irvin is present. Ma'am, if you had an opportunity to speak with a lawyer or someone that can give you some advice and direction regarding the matter that you now have before the court, ma'am?
I'm sorry. Can you say that again, sir?
I'm asking whether or not you had an opportunity to speak with a lawyer regarding your rights in this matter and regarding opportunities.
No, I did not, sir. No, I did not.
Opportunities that there might be to resolve your matter. And you've indicated that you have not spoken with anyone, ma'am?
Yes.
All right, so what I'm going to do, Ms. Urban, I'm going to set it up so that you can speak with a lawyer now that can give you some advice and direction regarding your rights in this matter. I'm also going to set the new date in this matter. That date's going to be the 9th of February, 2021. And that case is going to be heard at 9:15 on 2/9/21. That's when you come back in Zoom. But right now, I'm going to set it up so that you can speak with a lawyer in a private breakout room and discuss possibilities regarding this matter. Do you understand?
Okay, so you are allowing me to speak with the lawyer first before we proceed with anything.
Exactly right. Exactly right.
Okay, will I be receiving a court-appointed lawyer or do I have to hire one, sir?
Well, that's what I'm doing. I'm giving you a lawyer.
Okay, so you are giving me a lawyer and then you are telling me that I will come back on February the 15th, 2021, if I'm not mistaken, so we can proceed.
February 15th from, that's February the 9th.
February the 9th.
At 9:15 is when you come back into the zone. Got it?
At 9:15. Okay, sir. Are we coming at this time? Are we coming at this time? I'm sorry, not at this time. Am I going to use the same Zoom number to be able to come back into this courtroom?
Exactly right. Okay. So now the next thing is that today I'm going to put you in a breakout room to speak with a lawyer that can go over what your rights are and get you all there for the next day. Okay.
Okay. Thank you.
All right. So you're going to see a prompter on your device. It's going to tell you to go to a breakout room. And I'll get that to you in just a moment. All right. So who's available to speak with Ms. Irvin, please?
Okay, thank you.
Your Honor, I can speak with Ms. Irvin, but just to be clear, that doesn't necessarily mean I can represent her. I will advise her about her rights. I just want to make clear for the record and so that she understands that before we talk, and then we will go from there.
Very well. So I'm going to give you someone that can talk to you, give you some advice. And whether or not they'll represent you, that's a matter that will ultimately be determined. But right now, you'll have the opportunity to talk with this attorney Enright. So Ms. Irvin, I'm connecting you to Ms. Enright in breakout number 2. So you'll get the prompter that comes up on your device for breakout room number 2 in just a moment here.
And Your Honor, just so Ms. Enright knows, our file does indicate that our client is interested in EDP, if that's a possibility here. So
perfect.
Very good.
Mr. Flesland.
And Ms. Enright, I'm finding you now somewhere.
Your Honor, if I could be added to that breakout room as well, please.
That's Kakari?
Correct.
All right, very well. I don't know why I'm not seeing this. Oh, there you are. All right, got you. And Ms. Kakari, I'm going to take you out of the room that you were in and put you in.
Hello.
Thank you.
Should be there now, Ms. Kakari. All right.
Hello.
All right. This is case.
Hello.
Hello, if I haven't called your case, then just stand down and you'll hear, I'll call your matter as soon as I can get to it. Ms. Irvin, are you punching your device to put you in the breakout room?
I'm actually trying to figure out how I get to the breakout room, sir.
Did you see the prompter come up?
I did, but it wasn't, no one had joined me, so I didn't want to miss out on anything that you guys were speaking on, so I had connected in.
Don't worry about anybody else joining you. Just push that button so you can go there.
Okay, do you mind sending me the prompt again?
See, you messing up now. I don't know what I'm.
Sorry, this is my first time.
We're gonna send you west. All right, let me see if I can get you there. All right.
Okay, thank you.
You already have the prompter. Here's what I'm gonna do. You're gonna see a prompter for 3. Don't go there. And I'm gonna switch you back to 2. Okay? So there's 3.
Okay.
Now I'm gonna move you back to 2. You see it
Okay,
now?
thank you.
There you go.
Yep.
All right, good day.
Bye.
All right, this is case number 234851. This is Renaissance Village versus Brenda. That last name is Smart, regarding property located in the city of Detroit at 19391 Boulderbeck Drive. Matter appears to be one in which the court has received a proposed consent order of dismissal in this matter. Do I have Counsel Mr. Gann? Your appearance, sir? All right, do I have Mr. Lockhart? I'll strike at Mr. Phillips, Todd Phillips, Ted Phillips. Anyone from UCHC? All right, do I have
Judge, this is Lockhart. I know Mr. Gann is in Judge Millender's. I'm connected there now. I know nothing about this case.
All right, very well. I have received the proposed consent order in this matter. It looks like parties have signed off and submitted the order. Accordingly, I'm going to go ahead and sign the proposed consent order of conditional dismissal in this matter. The matter be conditionally dismissed on the terms as set forth in the submitted written document. This is case number 23475005. This is Armand Alamant LLC versus last name is Roberts et al. Regarding property at 6851 Woodmont. The matter is before the court where it seems that there has been the submission of a proposed consent order of conditional dismissal. Do I have the plaintiff for the plaintiff in this matter, please?
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
All right, thank you, Mr. Fantera. And I do see the proposed order. You signed off on that. Ms. Embright, I know is present. She's in a breakout room, I believe, right now. She signed off on that matter regarding her client. That's your understanding as well. Is that correct, sir?
Yes, Your Honor. And I know Mr. Enright is still in agreement with what we signed back in December. And she just went into a breakout room with a previous tenant. So we'd ask that the court enter that order as presented.
All right, sir. Let me just find out, do I have Ms. Roberts on the Zoom on Woodmont Street if you're here to say something? All right, I will sign off on the order as presented. Case will be dismissed conditionally on the terms as set forth in the written document is so ordered at this time.
All right, great. Thank you very much, Your Honor. Have a great day.
You too, sir.
Judge, what's the plaintiff's name on this case? I don't see it on the
Her
document.
first name is, I think it's Raven, R-A-I-V-Y-N. Oh, you said the plaintiff's name?
Yeah.
So the defendant's name, Raven Roberts. The plaintiff is Adamane, that's A-E-A-M-A-N-E, LLC.
All right, thank you.
All right, thank you. The court calls case number 346591. This is B Property Management versus Kevin Campbell, and occupants of property located in the city of Detroit at 1624 South Libo. The matter is before the court after being put on the 20th of October. It was set over for the 6th of November. The court was closed at that time. All right, your appearance regarding this matter, sir.
Good morning, Your Honor. Joe Horka, P75969, representing B Property Management.
All right, thank you, counsel. Do I have Kevin Campbell on this matter? Anyone living at the South Libo address? If you're on this Zoom, say something. All right, counsel.
Judge, at this time, you did mention this was our third hearing. I would request a default judgment enter in this matter.
All right, judgment will enter. Which one is that?
I can't tell.
Your Honor, Joe Horka, P75969 for the plaintiff.
Mr. Horka, I got you, sir.
I'm sorry, just
one moment, sir. I've got some noise here now. Please mute your device because I'm picking up some noise that's interfering here.
I think that should be better, Your Honor.
All right, thank you. All right, so I will enter judgment by default on this matter, and I will sign a judgment upon this presentment where a previous hearing was held and the defendant has not appeared on today's date. The court is awaiting the order, counsel.
Thank you, Your Honor.
Still has. All right, the court now calls 23-475-29, I'm sorry. This is Third and Grand LLC versus Denisha Nixon and other occupants of property located at 2911 West Grand Boulevard, number 4146. The matter is before the court on the filing of a complaint for non-payment of rent. Do I have Mr. Grant on this Zoom? Anyone standing in? Do I have Ms. Nixon on this Zoom? Anybody living at the West Grand address, number 4146. If you're on the Zoom, say something at this time. All right. It looks like the first hearing regarding this matter. Accordingly, the court will set the matter over, and that will be for the 9th. February 2021, the court is setting that matter at 9:15. That's the suffix 529. The court calls 23-477-70. This is Ross Holdings Company LLC Limited. LLC versus Lakenyan Robinson and other occupants of property on Rossiter 1180 Rossiter in the city of Detroit. Your appearance, counsel. I do see that there has been presented a proposed order of dismissal in this case, signed by both the plaintiff and by defendants. Accordingly, the court will enter this order, dismissing this case at this time.
Your Honor, apologies. This is Adam Devlin. I got an email from Steve Lockhart saying you set a Laura Waller matter for the 9th, I think, of February.
Yes, sir.
I had emailed your old clerk a dismissal on that. So I will send that to Hunter and yourself.
All right. Are you able to send that to my current clerk so I can sign off on
Yes.
that?
I will send it to Ms. Hunter right now. I apologize, Your Honor.
All right. I appreciate that, Mr. Devlin. You had two matters, I believe.
The other one was a conditional dismissal as well. I believe, I believe you have already entered that.
Yes, and that was your pleasure that the court would enter that conditional dismissal, correct, sir?
Yes, thank you, Your Honor.
All right. All right, thank you, sir. And just get that to us and we'll take that off of a future docket.
Right now,
it'll be dismissed. Thank you, sir. Okay.
Your Honor, Mr. Lee Ravitz has not answered me. I don't know if he
Let's see if we can get him.
can hear you.
All right. Mr. Ravitz, are you able to hear me, sir? Mr. Ravitz? Apparently not.
Okay, I just wanted to see if you could get his attention.
I'm trying to do that. Yeah, it's a bit of a curve here. All right. So let me come back to that. Just,
Okay, thank you.
I'm aware that we're trying to get there on this one. All right. This is case number 20. Mr. Ravitz, are you able to hear me, sir? Mr. Ravitz, if you will. Yes, sir. Mr. Ravitz, Ms. Seal, the attorney on that case that went to the breakout room, would like an opportunity to speak with you in the breakout room on some issue that may have an impact on the case. Do you have the space to do that, sir? Mr. Ravitz, you hear me, sir?
Looks like he's having technical issues.
All right, so Mr. Ravitz, I'm going to go on to another matter, but as soon as you're able.
Okay, I'm here, Your Honor. Thank you.
Oh, gotcha, sir. All right, so Ms. Seal, the attorney for it, depending on the other side of this matter, wants to talk with you in a breakout room. Do you have a moment to do that?
Yes, that'd be great.
All right, so Ms. Seal, what breakout room did I send you? Was that number 1?
Yes.
All right, Mr. Ravitz, I'm going to send you there. Ms. Seal is going back to that breakout room. You get the proper in just a minute. All right, this is case number 23-48167. This is A&A Property, strike that A&A Investments LLC versus Asia Williams and other occupants of property on Stair Street, 2398 to 2400. The court also calls the suffix 8170. That's Alden Towers versus Bruce Petty and other occupants of property at 8106 East Jefferson Avenue. The court is calling the suffix 8181 City Property Management Group versus Joel Williams and other occupants of property at 20300 McCormick Street. The court is calling the suffix 8528. That is Argo Property Management versus Tequila Wester. And I know that Ms. Wester is on this Zoom. That is regarding property at 15081 Mark Twain. The court is calling the suffix 8231. That is regarding Shaw, CHAND, Sutana versus Kenya Fife and other occupants of property at 19130 Huntington. The court is calling the suffix 8540. That is Marketplace Housing LLC versus Nikita Robinson and other occupants of property at 16201 Marlow. All right, your appearance at this time, counsel.
Good morning, Your Honor. Mark Corey on behalf of plaintiff for all the called matters.
Thank you, counsel. And with regard to any of these matters, is there any attorney that represents any of the defendants regarding these matters? If so, please speak up now. Counsel, if you are on either of these matters, please speak up now. All right. So I do know that I have Miss Tequila Wester on the Zoom. Good morning to you, ma'am.
Good morning.
All right. You live at the property there on Mark Twain. Is that correct, ma'am?
Yes.
So, Ms. Wester, have you had an opportunity to speak with a lawyer regarding your rights in this matter, regarding the opportunities that might exist to resolve this matter? Have you had an opportunity?
No, I have not.
All right, so ma'am, what I'm going to do is I'm going to set it up so that you can speak with someone that will be able to advise you and on this matter and give you some information about possibly getting it resolved. I'm going to reset the matter for the next action date in front of me. That will be the 9th of February 2021. That's going to be at 9:15 a.m. So what I'm going to do now is I'm going to set you up with a lawyer that you can talk with today. So you have the documentation for when you come back, correct? The 9th of February.
Okay.
Got that? All right, 9:15 on that day. That's when you come back to see me. I'm going to give you somebody.
9:15?
Yes, on the 9th of February. All right.
Okay, thank you so much.
All right, I'm going to give you somebody for you to talk to today that will go over what your rights are. And I'll do that in just a moment. Who's available to talk with Ms. Wester today?
I can talk with her, Your Honor, but I just wanted to let you know, can we do Ms. Williams' case before I go into a breakout room with her?
All right, I thought I set Ms. Williams' case over for our next action day. You need to come back on the record in that matter.
I just wanted to tell Ms. Williams that I will be sending the proposed conditional dismissal to the landlord's attorney, and that just to come to the next court date. I just wanted to let her know that.
Ms. Williams, you got that information?
Yes, am I gonna get a letter?
I will email you the information when I need your signature, okay?
Okay, so I can leave. Thank you.
Yes.
This
wish
will
you
be
well.
adjourned to
So much.
February 9th.
Okay,
Yeah. The new date is February the 9th, and your attorney will be in touch with you. All right?
yes, thank you, Judge Coleman. Have
All
a
right,
good
all the
day.
best. You too. Thank you, Mr. Radis, as well, Ms. Sill. Ms. Sill, you're in breakout room 1. Ms. Wester, I'm going to send you with Ms. Sill.
Yes, correct.
Okay, thank you.
You're going to receive a notification right about, let's see, let's get right to you. Now.
Thank you.
All right, do I have Asia Williams regarding property on Stair Street? Asia Williams on this Zoom?
Your Honor, this is a second appearance for this matter. Ms. Williams did not appear at the first hearing. At this time, we would request a judgment by default. We have $9,800 in rent owed, $153 in court costs, for a total of $9,953, a writ date of 1/25/2020. I believe this was filed as a money judgment. However, there was service by attachment, so I will be crossing up the money judgment portion.
Very well, counsel. The court will enter the judgment by default on the terms and conditions as requested, given that defendant has not appeared at the second hearing. So ordered. All right, with regard to the suffix 8170, Bruce Petty regarding property located at 8106 East Jefferson, D403. If you're here on this Zoom, say something at this time.
Your Honor, this case will be a dismissal. I believe it was sent in previously. We will resend a copy of the dismissal.
All right, the court, having heard you on this matter, will enter an order dismissing this case upon its presentment. Thank you, sir. Regarding the suffix 8181, that's Joel Williams regarding Coleman Street. If you're on the Zoom and you live at that location, please say something at this time.
Your Honor, what was that case?
This is the suffix 8181. That's city property versus Joel Williams.
Oh, yes, Your Honor.
Yeah, it looks like the first hearing on this matter, sir.
Wait.
I will say, I'm sorry.
Your Honor, I think this is the one we just discussed where it's a second hearing and then we were requesting.
All right, what did you say, counsel?
Your Honor, I think 8181 was the one we just talked about. There was a second hearing where we requested the default. I think we initially came like it's not on my calendar.
That was 8167. So 818. Let's see what we're doing here. 8167 is the one where you request entry of default judgment, and then 8170 was the dismissal. I'm looking at 8181 now.
Correct, Your Honor. I'm sorry. There are two Williams and
yes,
it's Friday. Your Honor, for this matter, if this is,
It looks like the first hearing on this one.
the first hearing?
I'm setting over for the 9th of February at 9:15.
Thank you, Your Honor.
Thank you. And with regard to the suffix 8231, do I have Kenya Fife on this Zoom? FIFE, regarding Huntington, property on Huntington? Looks
Your
like
Honor,
this is a. Go ahead, counsel.
Your Honor, this is a second appearance on this matter. The tenant did not appear at the first hearing as well. At this time, we request a default judgment. We have $5,477.50 and rent owed $130 and, or no, excuse me, that should be $130 filing fee, $75 attorney fee, and $27.50 in service fee. I don't have the total in front of me. Those are the fees. Writ to issue on 125. This was filed as a money judgment, Your Honor, and for some reason I do not have a proof of service in my file for this.
All right, I'll enter the judgment as prayed by default, and I don't see the return of service in the court's file, so I can't give you any direction there. But certainly, as an officer of the court, if it's not personal service, then of course I'll expect the judgment to be without the money portion.
Correct, Your Honor.
The judgment court.
Thank you very much, Your Honor.
Thank you.
I believe that's all.
No, 8540 Nikita Robinson regarding property on Marlow in the city of Detroit. If you are on this Zoom, please say something at this time.
Your Honor, this should have also been a dismissal that we sent in, I think it looks like in November. We'll be sending another copy of that dismissal.
Thank you, sir. The matter will be dismissed, and I am noting that on the file at this time. Thank you, sir.
Thank you very much, Your Honor. Have a great weekend.
Likewise to you, sir.
Hello.
You stand down until you hear your case call. Be right with you. All those are dismissal. Some of them have dismissal.
Okay. Hey.
All right, this is case number 20-346-837. This is Benjamin Sizemore versus Heather Sondergo and William Heineman and other occupants of property located at, looks like 19381 Elmira Street in the city of Detroit. Your appearance, please. Is Mr. Abbott here? Mr. Lockhart, are you there? I see a Will Heineman as well. Ms.
Yeah,
Hyman,
I'm here.
thank you. And sir, you signed off regarding a proposed consent order of dismissal regarding this matter. Is that correct, sir?
Yes.
All right. That looks like that document involves some EDP funds that are going to help with the payment of the rental obligation. And you wish the court to sign off on that matter at this time. Is that correct, sir?
Yeah.
All right. So I will sign the order consistent with the agreement that the parties reached. And your attorney will make sure that you get a copy of this in short order, sir. And I do wish you well. That's the end of this case.
All right. Thank you.
All right. Thank you. Good day to you.
You too.
This is case number 23-45248. This is Landmark Property versus Jaquita Hodge and Joe Thomas and Anisha Thomas regarding 17181 Puncher Train. Any persons connected to that matter on this Zoom? There is an order for administrative closure in this matter due to bankruptcy filing. The court is signing the stay order at this time.
This is Jaquita Hodges is on the call.
All right, well, it took you long enough, but you know what's happening in this case, correct, Ms. Hodges? Yes or no?
Yeah.
You know the case is, you know the case is stayed because of bankruptcy. You understand it, correct?
Yes.
All right. So I wish you well, ma'am. Until that is lifted, then nothing else will happen in this case. All right. All the best to you.
Oh, okay. Thank you.
All right. This is case number 23-40719. This is Landmark Property Management versus Jennifer Billings regarding property located at 8132 Weatherby in the city of Detroit. Do I have counsel on either side of this? I do have a proposed consent or order of conditional dismissal. All right, so do I have Ms. Billings on this Zoom? Say something if you're there, ma'am. All right, the parties have submitted to the court a proposed order. That order shows the signing off of all persons regarding this conditional consent order of dismissal involving EDP funds that were released.
Oh, because your background is too loud. I need to unmute it.
All right, so this matter will be dismissed as indicated. All right, this is case number 23-46980. This is Randall Acquisition and Property Management versus Eddie Dotson, an occupant's property at 70 Clare Street, apartment 2 East. The court also at this time calls case number 23-48155. That's Rose Point Apartments versus Charles Patterson and other occupants of property at 21758 Ross. The court calls 23-48059. That's JAIF Detroit LLC versus Stephen Teasley and other occupants of property at 15771 Steel Street. The court calls the suffix 8063. That's Charles River Real Estate LLC versus L'Oreal Calhoun regarding property at 13548 Medito. The court calls the suffix 8071. This is Midwest Property Management versus Salam Muslau and occupants of property at 8251 Manor Street. The court calls the suffix 8087. That's Prestige Realty Services LLC versus Quinard Sanders and occupants of property at 18838 Road in the city of Detroit. Your appearance, plaintiff in these matters, counsel.
Yes, Your Honor, may it please the court. My name is Dennis Flesland, P30289, appearing on behalf of the plaintiffs in those called matters. I am standing in for Mr. Sagatti this morning, Your Honor.
Thank you, sir. And sir, with regard to the suffix 6980 and 8155, I do see contained in the files of those matters a proposed order of dismissal, and the court is signing those orders at this time.
Thank you, Your Honor.
With regard to any of these other matters, are there any opposing counsels that are here with regard to these matters? Please say something if you are an attorney representing one of the defendants in the remaining matters. All right. Do I have on the Zoom Stephen Teasley? Stephen Teasley at Steel Street in Detroit. If you're on this Zoom, please say something. I do see Mr. Quinard Sanders on Kelly, so I'm coming to you in just a moment, Mr. Sanders. It looks like Teasley has not appeared. This is looks like a second hearing regarding this matter. Counsel, is that correct?
This is the second hearing, Your Honor. We were here on January 15th. Mr. Teasley still has not appeared. I would request a default judgment at this time.
All right, the court will at this time allow for the entry of judgment by default and will sign an order of the same upon presentment to the court.
Okay, thank you, Judge.
Okay, with regard to the suffix 8063, that's L'Oreal Calhoun. And I believe that this is a second hearing on this matter as well. Ms. Calhoun, are you on this Zoom at this time? Say something if you're there. Ms. Calhoun. Counsel, does it
Yes,
reflect
Your Honor,
something?
this is the second appearance on this matter as well. I'd like to point out to the court that Ms. Calhoun was personally served on November 12th, and I would request a default judgment at this time.
Judgment will enter by default as prayed, and the court will sign the order upon presentment to the court. Regarding Musalam, I know this is a second hearing. Do I have any person regarding the property at 8251 Manor Street? Say something if you're here on the Zoom. All right, counsel.
Yes, Your Honor, this is the second hearing on this matter as well. We have not heard anything from Mr. Salam or Mr. Muslim or from an attorney on his behalf, and we would request a default judgment in this matter.
Judgment will enter now by default on the terms and conditions as prayed, and the court will sign the order upon presentment. In each of the orders, the defendant will have the obligation to pay the amounts past due on or before the 25th of January or after that date of written issue, allowing for eviction from said properties. I do see that Mr. Quinard Sanders is on this Zoom regarding the property on Kelly Street. Good morning to you, Mr. Kelly.
Yes, sir.
Mr. Sanders.
Good morning, Mr. Sanders.
Good morning.
All right. So you live at the property on Kelly. Is that true, sir?
That's correct, Your Honor.
So did you have an opportunity yet to talk with a lawyer that might be able to give you some advice and information regarding this case and how you might resolve it, sir?
No, Your Honor. I haven't talked to anyone.
All right, so Mr. Sanders, I'm going to set it up now so that you can talk with someone today. And then I'm going to give you your next date to come back in front of me. That date's going to be the 9th of February of 2021. That's going to be at 9:15 a.m., February 9th at 9:15 a.m. That's when you'll Zoom back in and use the same number that you used today. But I'm going to give you someone that you can talk to so you can go through what the facts and information is concerning your case. And I'll hook you up with somebody in just a moment, sir, right? Is there someone available to speak to Mr. Sanders at this time? The lawyers may be in breakout rooms or whatever at this time. So Mr. Sanders, just hold tight. I'll get you to someone just as quickly as I can, sir.
Thank you, Your Honor.
Your Honor, we had one last one. It's a, it should be a 10:30 case. I don't think anybody has appeared.
What's the suffix on that?
8563.
I'm here.
Ms. Weaver?
Yes.
Okay.
All right, that is case number 20348563. This is Grosse Pointe Apartments versus Anita Weaver and other occupants of property at 21802 Moross in the city of Detroit. Counsel, Mr. Presley, you previously indicated your appearance, and that will be continuing.
Okay.
Ms. Weaver, you on this Zoom, is that correct?
Yes, I'm here.
All right, what's your name for the record?
Anita Weaver.
All right, thank you, Ms. Weaver. Just 1 second, let me put your name there. All right, Ms. Weaver. Now, Ms. Weaver, did you have a chance, opportunity to talk with anyone regarding your rights and any factual issues regarding this matter, ma'am?
No, I haven't. But I since paid the amount that they were asking for at the time.
Okay. So, do you believe or do you think that there is any balance that is owed at this time?
Well, yeah, there's a small balance, but I spoke to the apartment management and we've made arrangements, or been making arrangements to make payments.
All right. Now you know that you have the right to talk with a lawyer. Would you like for me to set it up for you to talk to someone at this point?
Yeah, you can.
Okay.
Yes.
All right, let's do it. That doesn't take away, I don't think, from the efforts that you're already involved in. It looks like you may be close to getting this resolved. So I want you to pass it by a lawyer, let them know what's going on. I will set a new date in this matter for the 9th of February 2021 at 9:15 a.m. That's when you can come back into the Zoom. Of course, if you got the matter all resolved, you won't have to come back, but that gives you a control date in which you can come back to this court. You understand?
Okay, you said, good question. You said if the matter is all resolved, I don't have to come back?
That's correct.
Okay.
Yeah.
And that's set for what, February 9th, you said?
February the 9th at 9:15.
Okay.
All right. Now, before you go anywhere, I'm gonna set it up so that you can talk with someone that can go over your rights and go over the facts of your case with you. Understand?
Okay.
All right. So just hang tight there. All right. I got one in front of you, but I won't forget you when you get someone to talk to you.
All righty. Thank you, man.
Thank you.
Your Honor, do you need me to stay while those two wait to talk to a lawyer, or am I free to go?
I think you're all set. You got the dates on those matters. And
I do, Your Honor. Yes. Thank you very much.
Regarding those matters. All right. Now, I do have 23466615. That's Bordale Development versus Alexander Gonzalez regarding property at 1915 West 4th Street, number 306. That matter was heard in October, and it was set over for the 6th of November, and then set for hearing on today's date. Do I have Mr. Gonzalez on this matter? I have Alexander Gonzalez. All right.
But they have retained, that's the other attorney. And the PPA.
So there is an attorney on this one?
Yeah, and the other one is, I think, the name of one of those.
So do I have
No one's on here.
do I have someone representing the defendant in this matter, Gonzalez? I have a notation on my file that someone from the Housing Coalition or one of the agencies might have some involvement with this person. If so, let me know. All right. I'll come back to that matter. Thank you. This is case number 23-4-8552. This is River Towers versus John McClintock and other occupants of property at 7800 East Jefferson. The court also calls the suffix 8556. That's River Towers versus Jackie Franks and other occupants of property at 7800 East Jefferson, apartment 48. The court calls the suffix 8560. That's River Tower versus Walter Williamson and other occupants of property at 7800 East Jefferson, number 1528. Your appearance at this time, please.
Judge, good morning. Robert Novak appearing on behalf of the plaintiff for Lee Rabbits. Your Honor, you had called Jackie Franks. We had submitted a dismissal to the court a couple of days ago.
Sir, your P number for the record, please.
I'm sorry. P58044.
Thank you, Mr. Novak. Mr. Novak, I do have the proposed order for dismissal regarding 8556. I am signing it at this time, sir.
Thank you, Judge.
He sound like a ass.
Mrs. Kim, all right.
The judge is very firm. Do you hear?
All right, just stand down, Ms. Kim. You're not on mute, so it's kind of.
But at this point, mine is word of mouth because I ain't turning none of that shit into the court, but I don't really have to. Oh.
Ms. Kemp, I'll be right with you, ma'am. I'll be right with you. All right. Regarding the suffix 8552, do I have Mr. McClintock or anyone at the 409 location, East Jefferson, the 7800? John McClintock or anybody at that location? All right. What about? I'm sorry. John McClintock, please. Who is that? All right. All right. Thank you, counsel. It looks like Mr. McClintock has not appeared on this matter. It is set as the first hearing, so I will go ahead and set it over for the next hearing date. And actually, I'm going to set it. I'm going to set it for the 5th of February. This is just a second here.
Okay.
I'm going to set it for 2/5/21 at 9 o'clock a.m. That'll be the second hearing on this matter. I also have the suffix 8560, Walter Williamson, 7800 East Jefferson, 1528. Mr. Williamson, you on this Zoom, say something, sir. Walter Williamson. All right. That one will be set for the 5th of February as well, 9 o'clock a.m. As the second hearing. If defendants do not appear at that time, the court will be inclined at that time to grant judgment by default in those matters. So ordered. All right. I have two matters that are waiting to speak with a lawyer. There is a matter involving Miss Anita Austin, and I've set a date for the 9th of February 2021 as return date, 9/15. I've done that in both of the cases that I have pending before me for persons awaiting this for a lawyer. The other matter involves Mr. Sanders. Mr. Sanders lives on Kelly Road. The suffix is 8087 on that case, and he needs to speak with a lawyer as well. Who's available, if anyone, to speak with either of those persons at this time?
Your Honor, I can speak with one of them, but can I just ask if Mr. Gallick is in the courtroom so that Miss Wester could speak with him in a breakout room?
Mr. Gallick is not in the zone. He bid me a good weekend a short time ago.
Okay, then Miss Wester, I will send you his email and phone number for you to contact him. That's all I had to say to Miss Wester.
Okay, thank you.
You're welcome.
Thank you, Ms. Wester. All the best to you, ma'am.
Thank you, sir.
Judge, you had called Rivers Towers. They were all adjourned until the 5th.
That's correct, sir.
All right, you were
Except-
breaking up. I couldn't hear you.
Oh, I'm
breaking
sorry.
up.
Yeah.
You have a good weekend,
Yeah,
Judge.
all right, till the 5th of February, 9:00 a.m. That's the second hearing. And
Beautiful.
if there's
Thank you.
if there's no appearance of default with it.
Thank you.
All right, so Mr. Sanders, where are you, sir? Mr. Sanders?
You're in a
I don't
breakout
see
room.
this.
isn't it?
Did I send them already?
Your Honor, when you put me in a breakout room with somebody, can you also put Rima Kakari in there with me?
Yeah, you
From
want that by default, huh? All
I'm
right.
sorry. I'm
I
sorry.
said, you want that by default, huh? Okay. I see that. All right.
Thank you.
So I don't see Mr. Sanders right now. It looks like he's not, he was waiting. But I do see Miss Weaver. Miss Weaver, you're still there, is that correct? Ms. Weaver?
Yes, I'm here.
Okay. I thought I put your name in. Did you hang up and call back or something?
No, I didn't.
I don't see your name again. I remember writing you in. All right, Ms. Weaver, I'm sending you to breakout room number, is that number 1, Ms. Seal?
Yes.
You said,
Yeah, I'm going to send you to breakout room number 1, Ms. Weaver, and you're going to get the prompter right now to go there, and there it is. Ms. Seal will meet you there.
And then Miss Kakari, if you could join breakout room 1 with me, that'd be great.
Ms. Kakari is with Ms. Emright in breakout room.
Oh, she's back.
We're back.
Okay, got you. I'm switching you over to 1.
Thank you so much.
There you go. All right.
Thank you, Your Honor.
All right, thank you. Mr. Sanders, are you there anywhere? Mr. Sanders? All right, this is case number 20-34-8567. This is Friendship Mellows 1 versus Gerald Davis and other occupants of property at 4120 Rivard, apartment 611. Court also calls the suffix 8571 Elwood Towers versus Sean Guyton and other occupants of property at 1325.
Wait a minute. Judge, can you call that case over? I can't hear. It's all
All right,
the
got you.
2571.
Find out where the noise is coming from.
Yeah, I think that was Mr. Parker.
All right, so 20-34-5867, Friendship Metals 1 versus Gerald Davis and occupants at 4120 Rivard, number 611. The court also calls 8571 Elwood Towers versus Sean Guyton and other occupants of property at 1325 Shane Street, apartment 314. Your appearance at this time, counsel.
Good morning, Your Honor. Joe Horka, P75969, representing the plaintiffs.
All right, thank you, Mr. Horka. And is there any counsel that's representing either of these defendants, Mr. Davis or Mr. Guyton? If so, say something at this point if you're an attorney. All right, so do I have Mr. Gerald Davis on the Zoom? Say something if you're here, sir. Do I have Mr. Sean Guyton on the Zoom? Say something if you're here, please. Any occupant of 1325 Shane? Any occupant of 4120 Rivard, number 611? All right, counsel, it looks like it is the first hearing with respect to both of those matters. Accordingly, I will set those matters over to the 5th of February at 9:00 a.m. for the next hearing date, simply as a second hearing where defendants have not appeared. They did not appear at that time. The court would entertain a motion for entry of default judgment.
Your Honor, actually for Elmwood versus Guyton, we're moving to dismiss this matter without prejudice.
That is, all right, that is the suffix 8571. The court will indicate that matter is dismissed.
Thank you.
And I do, you know what, I just found the order, counsel. It wasn't in the file, but I just saw it sitting aside. I'm signing.
Perfect. Thank you, Judge.
All right, this is.
Your Honor, this is Lockhart. May I interrupt?
Yes, sir. Go right ahead, Mr. Lockhart. I called your matter. And I called for you and I believe Mr. Abbott, correct?
Yes. We're just making sure a CD was entered.
Yes.
File ending 837.
Yes, sir. Consent order of dismissal was entered as presented.
Judge, thank you so much for allowing me to interrupt.
All right, thank you, sir. All right, this is case number 23-48575. This is St. James Cooperative versus Romamar Hughes and other occupants of property at 17184 Ventler, number 201 in the city of Detroit. Your appearance, counsel.
Good morning, Your Honor. Matthew Nichols, P78297, appearing on behalf of the plaintiff.
All right, thank you. Thank you, Mr. Nichols. Let me see if is Hughes on this zone. Last name Hughes, living at property on Ventler Street, 201. All right, counsel, it does appear that it is the first date regarding this matter. I will then set it over for the 5th of February at 9 o'clock a.m. 5/25/21 at 9 o'clock a.m. If the defendant does not appear at that time, the court will entertain a motion for entry of judgment by default.
Thank you, Your Honor. Noted, and you and the rest of your staff have a wonderful Friday.
Thank you, sir. Good day and weekend to you, sir.
Okay, bye-bye.
I did see Mr. Sanders return to the zone. Mr. Sanders, are you there, sir?
Yes.
All right. I was looking for you earlier. I had a lawyer to talk to you. Is anyone available to talk to Mr. Sanders at this time?
Oh, man. Okay, I'm sorry, Your Honor. My phone, my device had died.
Not a problem, sir. That does happen. So just stand tight. I believe Ms. Enright may be able to speak with you at this time. Is that correct, Ms. Enright? All right. So Attorney Enright is going to speak with you. And so I'm going to send you to breakout number 2. And you're going to receive a prompt from me in just a moment, sir, to go to breakout room number 2. There it is, sir. And Ms. Enright, I believe you can go back. I do see that Mr. Urban still in that room. So let me move him out of there. All right, this is case number 19-359-828. This is Delana Kemp versus Omanda Kemp and other occupants of property located in the city of Detroit. That's going to be at 11059 Finley Street. The matter is before the court on the filing of a complaint to recover possession of property. All right, your appearance at this time, counsel.
Charlene Snow from United Community Housing Coalition, P26923. on behalf of defendant, Mr. Omanda Kemp. I don't know if he's the gentleman in the car. Yes. Okay.
All right, you are Omanda Kemp, is that correct, sir?
Yes, sir. Amanda Clark Kemp.
All right, just one moment, sir. Put your name in there. All right, and your name for the record, ma'am, the plaintiff in this matter, please, if you will.
Yolanda Kemp, Your Honor.
All right, thank you, Ms. Kemp. And Ms. Kemp, you own the property on Finley Street, is that correct, ma'am?
Yes, sir.
All right, all right. Ms. Snow, I see that you filed an answer or a response of pleading in regard to this matter. You may at this time, ma'am.
Thank you, Your Honor. Yes, I did. I filed an emergency motion for relief from judgment and to stay proceedings and a motion to deny the writ application. Essentially, Your Honor, we're bringing this pursuant to MCR 2.612 CA, sub A, sub C, sub D, as in dog, and sub F. Your Honor, it's in fact, Ms. Kemp and Mr. Kemp are brother and sister. I believe they're twins. That's what I was told. But there are a number of issues here, Your Honor. The case was brought in 2019 against occupant when in fact plaintiff knew very well that it was her twin brother living in the home. And there was a default judgment entered. And I believe that a writ was signed in this matter on September 30, 2019. And nothing happened as to that writ for basically 1 year. And over a year from the time of the original judgment, which I think was on September 4, 2019. And then in September 24, 2020, plaintiff came back into the court on the original judgment from almost a year ago in 2019 and seeks a writ on that 2019 judgment. And we are saying that there are a number of issues here. Number one, it is certainly there was some originally in 2019 when the case was filed against occupant, when she knew very well that the occupant in the house was her brother and her nephew. She didn't name any named defendants, which in some way misled the court. If the court had seen the name, the same last name, one might have inquired whether they were related, whatever happened. I think there was not a lot of hearings here before the default was entered. One might have assumed it was just some unknown person staying in the home, when in fact it was the home of their mother that Mr. Kemp was in. The mother passed away in 2016. He continued to stay there after their mother passed with a nephew. And then in 2018, the plaintiff came to the defendant who has some reading difficulties, which at some point maybe we can, if we were in real court, I'd do a sidebar. I don't know what to do in virtual court regarding his various disabilities. So in 2018, plaintiff has defendant signed some papers from probate court. He thought those papers had something to do with her helping to pay the taxes on the property. We can ask him and some questions. Your Honor, I think this needs to be, I don't know how much you want me to get into this. We're alleging that in fact, there was certainly some mistake in the way in which she got this property. We may want to look at that in probate court. That He didn't know what he was signing. He did not know he was giving up his inheritance rights to mother's home, which is in fact what happened here. And the plaintiff, I understand there are 4 siblings. The plaintiff got all the siblings to sign waivers and consents. I don't know whether they all understood what they were doing on information and belief. I don't think they did. And she got the house, and then within a year, in August or September of 19, filed against her twin brother to get him out of the house. Your Honor, so we are contending that it falls flatly within 2.612. Defendant, I think my documents lay out where we are. He has done work in the house. He has a little repair business out of the house. They had a judgment in 19. If she wanted to go forward, they had a writ signed 5.5 months before the pandemic hit. And now, then they waited well over a year to apply for a new writ. We contend that it's stale. They can't they should not be allowed to have a new writ on a judgment from September 19 when they had one writ and then waited a year. This is not like they waited 56 days. They waited 12 months to come back. Meanwhile, he's staying there. We ask that there be relief from the judgment of September 4, 19, and the writ be denied and the case be dismissed. Your Honor, we also ask that we filed an emergency motion to deny the writ application on many of the same grounds. Defendant did not attend the original hearing because he had not received a copy of the court papers. He didn't know he was supposed to be in court in September 19. So that's essentially where you are. We think that there has been some mistake or inadvertence or maybe excusable neglect in never naming that the case was against her twin brother, was against her brother. Not just general occupant. In terms of what's going on from the probate court that started all of this rolling, we wonder if there is some misrepresentation at best. Maybe something more going on there under C1C. And we think it would be appropriate and just not to allow the writ to go forward at this time on a September 2019 judgment. So that's where we are. If you want to have a further hearing, Your Honor, we can do that. I can ask questions of Mr. Omanda Kemp, and I understand there's a Jamal Kemp who is another brother who may have testimony as well as to what his understanding was of the probate matter.
Thank you, Ms. Snow. Ms. Kemp, did you receive a copy of the document, the motion that was filed by Mr. Kemp's attorney?
Yes, Your Honor.
What do you wish to tell me at this time?
There were a lot of mistruths told to Mrs. Snow by the defendant. Initially, there are 4 siblings, including myself. No one was forced to sign anything. That was a step because the defendant was staying in the home. The house went into foreclosure 2 times before this even came about. And he started handing me property tax bills, in which I paid because I cared for my mother. I lived in the home prior to my mother's passing. He did not care for my mother. There was a lot of mistruths told in court, Your Honor. That being said, as far as him being illiterate and as far as him not receiving paperwork, I have informed delivery from the United States Postal Service that I see every piece of mail that goes to that address because I used to live there. So he was informed. He also made his way to the courthouse on that day that we had the court date. He was actually there. I saw him. So he made it there. He just didn't make it, I guess, in time or whatever. I don't know, but he was there. He is not as illiterate as he's claiming to be. And as far as the initial writ was concerned, I had given him time prior to this because I was paying the property taxes. I was paying it. So he's been there for 4 years and hasn't paid anything. Not to mention, every utility is on illegal. He does not have anything running. He has sold the furnace out of the property. When I came to you with the writ initially, I asked not for damages or anything because he's not going to pay anything. He has a career of squatting in people's properties. Period.
Let me ask you, Ms. Kim, why didn't you have the writ executed back in 2019?
Because when it initially started, my mother, when my mother was living, I was in the home with my mother and caring for the 2 children, which one is Jamal that he's saying that lives there. I had primary guardianship of those children until they turned 18 because I was caring for my mother. She had it prior to, and when she fell ill, I maintained guardianship to help out. So we all 4 stayed in that home. The defendant never stayed in that home. With that being said, my mother purchased the home in 2010. And when she purchased the home, because you assume responsibility for prior year taxes, when she purchased it, she already had 2 years of taxes from the previous private owner that she purchased the home from. So by my mother, she was on a fixed income. She fell ill and she applied for a hardship. I helped her apply for a hardship, the Michigan Step Forward program. She was to stay in the home for 5 years, and her taxes, the back taxes, because she had a problem with staying current because, she was on a fixed income and I was helping out as much as I could. But she had to stay in the home 5 years and her property taxes will be free and clear and brought up to date. She passed 3 years into that agreement, and the defendant was in the home at that point because I would allow him. He was squatting in another property, which he got sent a letter and they told him that they needed him to exit the premises. That is the only reason the defendant was at that property to begin with. However, he defaulted by not paying the property taxes, so it went into foreclosure. And after that, he fraudulently went downtown and got a payment arrangement in my deceased mother's name and bragged about he had a payment arrangement and was to only pay $98 a month. He never made any payments at that point. So he was giving me the property tax bills for me to pay him. He asked for my help to pay the property taxes. I can't afford to take care of a grown, competent man living expenses as well as my own. I can only afford to take care of myself. I was in the property when my mother passed, and we were splitting everything down the middle. My mother was on a fixed income. When my mother passed, I didn't want to resume the responsibility of taking care of adults. I didn't want to do that any longer.
All right, so here's the challenge here, and this just one moment. Ms. Snow raised a number of issues that certainly the court will not even get to those issues in the context of this case. The big issue here is a landlord-tenant case. It's a case that's brought pursuant to the Summary Proceedings Act. The Summary Proceedings Act for the state of Michigan is called that because it is a summary act, and it's designed to be accelerated. It's designed to move things forward quickly so that there is no miscommunication or change of directions as to what a party's intent may be. And so what happens in this case is that you filed your complaint, gave you notice apparently sometime back in in July. You ultimately filed a case in August of 2019, and you made it to court in front of me on September the 4th of 2019. And on that date, the court did enter judgment by default. The time was ticking up until that time. And after that time, the time is really ticking in this case. That means that if you're going to assert your rights to recover possession of the property, you have to move with all diligence to do that. Otherwise, it distorts what the nature of the case is. You did react swiftly by filing your application for writ of restitution on the 25th of September 2019. I signed it on the 30th. The time is really ticking then. And after the 30th of September, the next action, September 30th, 2019, the next action taken in this case is in September of 2020. That's a year later. You can't do it that way in a landlord-tenant case. The case becomes stale, and what happens under those circumstances is that you have to start over because you've allowed for unreasonable delays with respect to this matter. A difference would be a scenario where that is unlike this case. Let's say that you filed a case that involved non-payment. Let's say that in the context of that non-payment case, the person agreed to make incremental payments. And let's say they were paying you for 6 months, and then they stopped with the incremental payments. After 6 months, they don't pay you no more. And then you file for an update of the writ of restitution. You can show that for 6 months we had an agreement that they were going to pay me. Then they stopped paying me the amount that was owed under the judgment, and so therefore, judge, give me a writ. Here, there is no reasonable explanation as to why no writ was executed. That first writ was not.
Watch out, vehicle stopped on shoulder ahead.
So let me stop all this. Madam Court Reporter, did you see where the noise is coming from?
I can't really tell.
I'm sorry, it came from the person on driveway. I want nephew right now.
Let me mute you. Can you mute yourself there, Mr. Kemp?
Yes.
Yeah, go ahead and mute your device, sir. Thank you. All right. So this case is unlike that scenario. This is just an unjustified, unreasonable delay in taking further action based upon a judgment that was entered. Now, I don't address the issues with regard to the probate court, with regard to the family agreeing under some scenario to sign over the property rights to Ms. Kemp. It seems that you have an order from the probate court that gives you administration or that has conveyed the property to you. If someone wants to challenge that, they'd have to do that in a different setting. That's not really challenged here. And whether or not there is some difficulty reading or fraud or anything like that, I'm not addressing any of that. I don't even express a belief that that is the case. I know that these are family matters. My sister is living in my mother's house now, and there are 8 of us siblings, and so I understand how those kinds of things can go. But when you bring a matter into the probate court under the Summary Proceedings Act, you have to act consistent with what your desire is. You can't have a writ to have a person evicted out of the house. A sheriff come, a bailiff come and move them out of the house, and then number one, don't act on that. Then show up a year later saying, I want my writ to be executed. You can't do it like that. You have to start the case over again. And that's really the problem. All of the other issues are issues of dispute. The problem in this case is the delay. And I'm not going to let you go forward on a writ that is a year and some since about a year and a half since the filing of the case. You can't do it that way. Ms. Kemp, I see you have your hand up, so go ahead, man.
It was actually not like I have a lot of documents and paperwork that was prior to the actual writ that was signed in 2019 that wasn't able to submit to the court because I had no way of doing so. It was an act of due diligence on my part, but at the same time, because he was my brother, I tried to give him time to make a transition, to make an accommodations for himself. However, with that being said,
let me stop you for a moment. Anything that happened before you filed the case in front of this court, I'm not really addressing that. Obviously, if someone were to bring an action, those issues would come into dispute. The only thing that this court is addressing really is very narrow, because that is dispositive on the issue that is raised here. And that is from the time of bringing this action before the court and ultimately up till today. And you did everything that you were supposed to do to come to court. You certainly did that. You got a judgment by default, and you got it timely. You filed a notice, you came to court, you got the default judgment, and then a couple of weeks after that, you filed the writ application. But then and the court signed the writ, allowing for the bailiff to remove the person from the property. Nothing happened further until a year later. And I understand, and that's why I kind of mentioned about my 8 siblings. I kind of understand that you didn't, for whatever reasons, you didn't take a further action. If you didn't take further action for a month or 60 days under the court rules, there is such a thing as the 56-day rule. You could have delayed it, and within 56 days, and the court still would have been inclined to allow the execution to go forward. Shortly after that, you would have had to file a motion for the court to waive the 56-day rule. Here, we're not talking 56 days. We're talking a year. We're talking a year plus since the original writ was issued, and we're talking a year and a half or more since the original complaint was filed. All I'm saying is that in the context of this case, you can't get a writ now for a case that was brought to judgment more than a year ago. You can't get a writ to execute on that now. That's stale. It's what's called stale. Ma'am, you have your finger up there. Go ahead, Ms. Kim.
Okay, what I want to ask is, when this second one was done, I actually had to start the process over, so it wasn't really piggybacking off the 2019. Isn't that correct?
No, and that's it. But you have correctly identified what the problem is. Okay, you nailed it right there when you posed that question. What you would have had to do to bring that writ would have been to start the action on it. That's the problem. I kind of put it in legal parlance language, because I'm a lawyer and judge. But you put it in the common person's language, that what you would have had to do in the landlord-tenant division is to start a new case because of the delay. And that's the issue that I'm raising here. You have a right to start a new case. You have a right to give another notice and to move forward with this. But under this older case that started in July 2019 and was brought before the court, I think August, you can't in September of 2020 file a second writ application in this case. You can't do it that way. You would have to start the case over again, and you have every right to file a new case. And this is one of the problems that occurs sometimes, especially when there are persons who are trying to perhaps be benevolent towards somebody that they're working with. And say, for example, you have someone that don't have anywhere to go, so you're waiting and you're waiting and you're waiting, which can be a good and honorable thing to do. Under the rules that relate to the Summary Proceedings Act and and all of the issues connected to landlord-tenant cases, you can wait for a while. If you stretch that out too far, then you're gonna lose the opportunity to bring a writ to have a bailiff assigned to come and put that person out of the house a year and a half after the case came before the court. You're not going to do it. Not a landlord-tenant case. There are other kind of cases where that kind of delay does not become a significant issue. Landlord-tenant is different. Landlord-tenant cases, property rights and occupancy rights and things along that line are different, particularly because of what's called the Summary Proceedings Act, the act that speeds up things, that requires shortened notices and so on and so forth, and that puts restrictions on when and how and under what circumstances a court can order a bailiff to come out there and put a person's stuff out of a person's house. So that's kind of the catch-22 that you run into here. And for that reason, and for that reason alone, that's why I tried to separate out what may have happened before this and what may have happened since this. That has nothing to do with this. This only has to do with the four corners of this case. The defendant's counsel that filed a motion raised some other issues. Those issues, I don't even get to those issues. They might have been issues that the court could consider under another scenario. I don't even get to those issues. Just this case, where there's an application for a second application for a writ a year after the court entered a judgment. You can't do it. You gotta start such a case over and go through the process and get your writ application exactly what you did the first time. And I kid you not, I'm not trying to stroke you in any way with this. I tell you, the way you did it the first time, exactly right, precise. You even came back and got the writ right after. You came back and got the writ right after you were entitled. The document says that he had to move by the 17th. By the 25th, you were there to get the writ. I signed that writ 5 days later on the 30th. You did everything perfectly right. You did nothing else happens for another year. You can't do it that way. That next step was an error in this case that results in the court having to deny your application for writ with respect to this matter. Council's motion goes to an application for relief from judgment. At this time, at least as it relates to that portion of the judgment in this matter, I'll deny that motion. As it relates to the application for writ, the application for writ is denied in this matter. In this case, this file will be closed. Nothing prevents you from going forward in a new case. That stops everything here. There's nothing else that you can do with this particular case. That's my order in this matter. I wish you well, Ms. Kemp and Mr. Kemp. Thank you, counsel. Good day to all.
Thank you, Your Honor.
Thank you.
Mr. Kemp, I'm going to give you a call later this afternoon or Monday. Okay?
Okay. Thank you, Ms. Snow.
All right, Mr. Abbott, Ms. Snow, you'll be sending an order or something.
I was just going to ask, you want an order dismissing or an order denying writ?
Yes, ma'am. It should be an order denying the application for relief from judgment, but also denying the application for writ and closing the file.
Yes, I will send one over. Thank you, Your Honor.
Thank you. Good day. Mr. Abbott, I have 23-46615 Bordell Development Company versus Alexander Gonzalez. I didn't know what was going on in that particular matter. I know that we had other matters this morning, some that had a consent order in the court entered those. And you may have had something that was to be dismissed. We can go through it if you need to. But this is one that I have not taken.
Morning, Judge Coleman. Yes, I was in three of the courtrooms. As to case number 6615, I do have a signed conditional dismissal to the court. I can send a copy right now if you'd like.
All right, sir. And the court will sign the order upon presentment regarding that matter, Mr. Abbott. And Mr. Abbott, if there are other, case numbers that you need to check on, just give me those case numbers and we'll give you information in regards to those matters.
6837, I believe, is a conditional dismissal.
Madam Court Reporter, you see that?
Yeah, it's a dismissal.
Thank you.
Yes.
Also, 0719.
Conditional dismissal.
Okay, that leaves a case in the morning for me. That's case 5248.
That was, oh yeah. Administrative closure?
Yeah, that was a bankruptcy matter, correct?
Yeah, exactly.
The stay was lifted.
Oh, I didn't have anything indicating the lifting of the stay. The defendant was present as well. And I indicated that I saw the stay application in the file. So what we'll do, Mr. Abbott, is we'll set another date. I'll put it out. Like 14 to 20 days now. So we'll give it the 4th of February, and we'll send out a notice for that date, 4th of February, 9 o'clock.
Okay. I will email a copy of the order lifting the stay to your courtroom right now.
Great. Great, great. And on your representations, we're resetting, we're setting the date. We're going ahead and setting the date now at 9 o'clock a.m. on the 5th of February.
You want the 5th or the 4th?
The 5th of February.
The 5th.
February 5th.
Did my client appear on that?
No,
No.
no, no one said anything. The defendant, to my surprise, the defendant was present. And I asked the defendant, I said, I have in the file an application stating the proceeding. Is that what's going on in this case? She said, yes, it stayed. And I saw that in the file, so that's why I went in that direction. But we'll straighten it out. Sorry for the delay in that matter. I would set it earlier, but I want to make sure that we have enough time for it to get out in the mail. So that's why I'm going ahead and put it.
Yeah, so I apologize for not saying it earlier. I never saw an administrative closing. And she full well knew that the stay was lifted. She attended the hearing.
Yeah.
You probably remember the case.
Yeah, oh yeah, I remember the case. And I did have some wonder about whether it had been lifted, but I saw the form that is typically the form that you submitted, the order for administrative closing. And of course, now I'm looking, the timestamp on that was November the 2nd. And I had not signed that until today. So that's what led me to believe that it's still closed. All right, so we went ahead a little bit on you that time, Mr. Abbott. I do apologize. And we'll get it back just as quick as we can so we can go forward, sir.
Thank you.
All right, thank you, sir. So you know what to do.
Can you give me those times again? This is Tina with Landmark Property Management.
Hi, how are you?
Hello.
I think this is the first time.
Happy
I'm
New
seeing-
Year.
Yeah, you just chiming in there on my Zoom and not saying anything as you chime in. I don't know what makes you think that you can do that. Okay. All right. So what do you need?
I'm trying to get the next court date because we have a court date in bankruptcy as well, and it's waiting on the results of this of your case.
On this particular case that we were just talking about?
Yes.
Okay, that's the 5th. That's the 5th of February is when it's coming back at 9
I
o'clock.
said the 4th, though.
Yeah, I set it for the 5th on Friday the 5th, 9 o'clock a.m.
Not the 4th.
Not the 4th. I know I said the 4th previously, okay?
Oh, okay.
Yeah.
Now, is that the earliest date that we can get?
Yeah, because of the mail situation. That's why you saw me kind of hesitating here and there. And I've been instructed to, because of, we're still addressing mail type situations, to put a 3-week tail on it. So that's why you got the 5th.
Okay, thank you.
All right.
Yes.
Thank you. Hopefully the rest of our year won't be that way. I didn't know that was the case that you were dealing with. Now I know why you came in, didn't say good morning, good afternoon, nothing. Just all right.
It's been a busy day.
I understand. That one kind of slipped by. I don't like for anything to kind of get past us. That one did. We're gonna get into it straight out.
So I'm free to log off?
I think you're all set, Amanda. Good day to you. Have a good weekend.
You too.
Madam Reporter, I know that I had this one with Mr. Khan, Stephen Khan, the Planners Council. That's 6722.
722.
Detroit versus Sharita Watson.
You called it already, or you calling it now?
Yeah, I called it earlier, and so I was just kind of reflecting back on it because the defendant didn't show up. And someone, Mr. Khan, had been in the Zoom and they was in another courtroom. He did not come back on this one. So I think what we have to do is just set
Another date.
I'll set this over for February.
All right.
Mr. Horka, did you have something?
Judge, I actually have two matters left with you. They're both land contracts. One is against Miss Jackson Julks on the line.
Why don't I have those?
Which one is he talking about?
What's
the last three numbers?
What's the last three digits on that, Mr. Horka?
Sorry, just 1 second, Judge. Be right back, Judge. I'm getting called into Judge Wonders real quick.
That was the register of active user files I cannot find. Those are the register of active games. Yeah, good.
I don't say anything. It's yesterday, Tuesday. Oh.
Yeah.
Just hold it.
I looked up those files. I cannot find them.
All right, so do you have the file in this?
No, those are the ones I gave you back earlier. They, yeah, see, I gave you the register. I can't find them.
Oh, okay, that's what.
I can't locate them.
Okay. So you saw some files that I brought.
Yes.
You got those, that was not one of those.
No, you currently gave me those files back, so.
All right, so this is case number 20349293. This is Sky Residential LLC versus Yamisha Jackson Jules. And I don't have the file on this matter, but I noticed before the matter of land contract forfeiture. Looks like a court did have a virtual hearing a couple of times, or scheduled a couple of times in this matter. Mr. Hawker, can you update me? And I do see that Ms. Jackson, is it Jukes? How's that last name, ma'am?
Ms. Jackson Julks, can you unmute?
All right. So it's pronounced Jokes? I'm still not hearing you. You're on mute. So,
yes,
anyway,
I can hear. Good morning.
All right. Yes, good morning to you, ma'am. Say your name for me, please.
Yes.
You were unmuted, but you're muted now. Let me go to Mr. Horker. Mr. Horker.
Yamisha Jackson Julks.
All right. All right. Thank you, ma'am. All right. Mr. Horker, what's going on here, sir?
Yeah, I believe we were initially supposed to be here on December 3rd with closure. This would be our first court date. I don't believe Ms. Jackson Julks has been personally served, but if she's present in court and wants to discuss the case with me today, I'd be happy to do so.
All right. So ma'am, have you had an opportunity to speak with a lawyer regarding the matter that you have and regarding rights that you may have in this matter? You have an opportunity to speak with someone?
Your Honor, she's muted, but I did speak with Miss Jackson Jukes yesterday via telephone. Unfortunately,
No, Your Honor.
Lakeshore is unable to represent her at this time, but I did provide her legal advice via telephone yesterday.
All right, thank you. Thank you, counsel. So Miss, I understand that you spoke with someone yesterday and they're not able to represent you. Are you interested in trying to get someone on your own to assist you in this matter? Or that you want to try to move forward without the assistance of the lawyer? What do you want to do?
Judge, you're kind of difficult to hear.
All right. So Ms. Jackson, Jokes, are you able to hear me at this time? Yeah. For some reason, you keep going back to mute. You keep going back to mute, ma'am.
Is it possible if I could get a court appointer, lawyer?
Well,
Yes, I can hear you. Can you hear me?
I hear you now. Okay. That's what the thing with Lakeshore was to try to do that.
Can you hear me?
Yes, I do. Do you hear me okay? So the lawyer that we would have appointed, that office is not able to represent you in this matter.
Yes.
I can see it. Well, so you've not been able to get someone on your own to help you in this regard. Is that correct? Right, so did you want to speak with?
That's correct.
Okay. Did you want to speak with the lawyer for the plaintiff to see if maybe you could work something out here in this case? Do you want to try to do that? All right, so why don't I give you the opportunity to do that? And listen, if you can't come
yes,
to
Your
something,
Honor. Yes, Your Honor.
I got you. If you can't come to something that you believe makes sense to you, then I'll set another date and then try and see if I can get another agency to represent you. And so, but if you want to talk with this gentleman, then maybe the two of you can arrive at something that works for you. If it doesn't, if you don't think that it's working for you,
okay,
I'll try and set up something else. Okay. So, Mr. Horker, can I put you in a breakout room with Ms. Jackson Jones to see if you can maybe go through it and talk about it a bit?
Yes, please, Your Honor.
All right.
Okay, thank you, Your Honor.
All right. So, ma'am, I'm going to put you in breakout room number 2. And Mr. Horker is going to be there, and the two of you will have a chance to talk about this a bit. There you are.
Your Honor, is that all the cases on the docket for now, except those in breakout rooms?
Mr. Horker said that he had another. He said he had a couple matters in front of him, and I didn't inquire before he stepped out on what that last one was. So.
Okay, I'll stick around then, I guess, in case defendants show up.
I do appreciate it.
Okay.
Let me try and find out who's on this There's someone else there. Who are you under the 313, last four digits, 6043? Say something if you will. I know that you're on mute, but you have a cell phone, it looks like, when you call in. Tell me who you are. welcome back, ma'am. Welcome back, Mr. Horka. Mr. Horka, do you have another case other than this one as well?
Yes, I do, Your Honor.
I think it's up under that register of actions, two of them. That one.
All of these are the same case. I know that on this file, it has Mark Jolly as a defendant on. Is that the same matter? Oh, no. Okay, I see. Yeah, this is something different. Gotcha. All right, and that would be the suffix 20349-289, correct, sir?
Yes, Your Honor.
Okay, all right, we'll get to that in just a moment. Let me ask though, do I have Donnie Jolly on this Zoom? I have Donnie Jolly on this Zoom. All right. It looks like the defendant has not appeared on this matter. There was a previous hearing that was scheduled on the 15th, and I adjourned the matter over until today's date. I don't believe the defendant showed up at that time, correct, counsel?
Your Honor, I think this one is the first hearing. I'll double check my paperwork, but. And I'm noting on this one, we don't have personal service. So I was planning on asking for an adjournment for a motion for alternate service.
All right. So the court will grant your petition for alternate service in this matter, and we'll set it over. I'll go ahead and set it for the 9th of February, and I'll set that at 9:30 a.m. February the 9th, 9:30 a.m. And the court will sign the order of alternate service upon presenting. You believe that service by other means attempted service by other means have been exhausted, and alternate service is reasonably calculated to effectuate actual service, counsel?
Yes, Your Honor.
All right, so I will await the order for alternate service. The date is set for the 9th of February, 9 o'clock a.m. for the hearing.
Thank you, Your Honor.
We're back to the suffix 9293. Mr. Hawker, update me on this matter if you want.
I had a chance to speak to Ms. Jasmine Julks. I believe we're going to present a proposed consent judgment to you. The amount in arrears is $8,749 plus $165 in costs. $8,914 is the total. Less than 50% of the contract amount has been paid, so it'd be a 90-day redemption period for April 15, 2021.
All right, and Ms. Jackson-Jolch, you have heard the numbers and the scenario that's been presented to me. Is that something that you wish to go forward with, ma'am?
Yes.
And I know that you don't have an attorney in this matter, and I know that you attempted to have someone, and that person was not able to represent you. Are you satisfied that you are able to go forward without the assistance of an attorney in resolving this case based upon the terms that you've talked about?
Yes, Your Honor.
All right, then I will sign the order as it's presented to me, and that order will enter. And I know this is a land contract matter. Is this a 90-day or a 66-month situation, Mr. Parker?
90 days, Your Honor.
All right. So you understand that the amounts that's in default would have to be resolved over that 90-day period, or you will stand to lose the property if it's not resolved. You understand that?
Yes, Your Honor, I understand.
All right, I'll sign the order, ma'am, and you'll get a copy of that order. And I do wish you well in this regard, ma'am.
Okay, thank you.
Good day to you.
Judge, should I sign Ms. Jackson-Jolks' name with her permission, or just leave it blank?
Ms. Jones, the lawyer is going to sign off indicating that this is your agreement, that he has to consent to simply sign off on the documents. That makes sense to you?
Yes, Your Honor.
All right, very well. Thank you very much, ma'am. All right. And you'll get a copy in short order.
Thank you.
Thank you.
Thank you, Your Honor.
Okay.
And Ms. Reamer and Ms. Seals, that concludes matters, and I do appreciate your involvement and your assistance in regard to these matters today. Good day to you and a wonderful weekend.
You're welcome, Your Honor. You're welcome, Your
Have a
Honor.
great
Have a
weekend,
nice
Your
day.
Honor.
I'm sorry, what did you say, Ms. Seals?
I said, have a nice day, and I think Remus said, have a good weekend.
All right, thank you, guys. All right, all the best.
We'll see you
next week.
Yes, indeed.
All right. Bye-bye.
All right, everybody have a great weekend.
You too, Deborah.
All right, Deborah, you be good. You made it through this week. I didn't know I was gonna have to,